All rise, we will obey. The International Criminal Court is now in session. Lord John the Court Panel International at 08. Please be seated. We will also.
Good morning, everyone. I would like to welcome all of you into this courtroom. Madam Court Officer, could you please mention the case?
Good morning, Madam President, Your Honours. This is the situation in the Central African Republic 2 in the case of the prosecutor versus Mohammed Said Abdelkhani, case reference ICC 0114-0121, and for the record, we are in open session.
Thank you very much. Counsel, can you please introduce yourselves, starting with the prosecution, please?
Good morning, Madam President, Your Honours. My name is Karim Khan, and I lead the prosecution in this case. I'm joined on my left by Deputy Prosecutor Mr. Mande Nyang, trial lawyer Leonie von Braun, and then behind me we have the senior lawyer in the case, Hollow McQuay. We have Miss Brunhild and also Miss Adriana Rodriguez, and then right at the back we have Ramu Biche, our case manager, Sanyu Dagire, also a trial lawyer in the case. Thank you.
Thank you very much, Mr. Khan. Counsel for the victims, please.
Merci, Madame la Présidente. Bonjour.
Ms. Pillay, thank you very much. The victims in this case are represented by Adeline Budusha, Tars van Litzenberg, and myself, Sare Pillay, counsel within the Office of Public for Victims.
Thank you very much. Defense counsel, please.
Merci, Madame la Présidente.
Ms. Nauri, thank you very much. Beside me today, Dov Jacobs, Associate Counsel, Léa Alix, and behind, François Jacquemin, Valderiez, and Manon Lasselle. And as for myself, I am Jennifer Nauri, lead counsel representing Mr. Said. Thank you.
Thank you very much, Ms. Nauri. I don't know if we have any representative from the registry. Anybody from the registry? No? Okay. For the record, I take note that the accused, Mr. Said, is in court. So for members of the public, let me quickly introduce the chamber. I myself, I am Miata Maria Samba, and I'm the presiding judge. To my immediate right is Judge Socorro Flores, and to my left is Judge Sergio Ogalde. As you are aware, we're here today for the opening of the trial of Mr. Said Abdelkhani. For the record, Mr. Said Abdelkhani indicated to the chamber in January that he goes by the name of Mohammed Said. So we will be referring to him as Mr. Said in these proceedings. I will open with a few preliminary remarks, and then the charges will be put to Mr. Said. We then intend to hear opening statements by the prosecution. This will be followed by the opening statements of the legal representative of victims and then the defense. As an introduction, I wish to provide some short background information to this case. On the 30th of May 2014, the government of the Central African Republic referred this situation to the court. This referral pertains to crimes within the court's jurisdiction that may have been committed since the first day of August 2012. On the 7th day of January 2019, the pretrial chamber issued a warrant of arrest against Mr. Said. He was surrendered to the court on the 24th day of January 2021, and made his first appearance on the 29th day of January 2021. On the 9th day of December 2021, the pre-trial chamber confirmed the charges against Mr. Said, which are now brought before this court. Today is the opening of the trial. At this juncture, I'd like to emphasize that the chamber is aware of the importance of parties being able to fully present their case. At the same time, we wish to stress that we will expect the trial to be carried out in an effective and expeditious way, not only for the benefit of all participants, but more fundamentally for the benefit of the accused and the victims. We will now turn to Rule 134 of the Rules of Procedure and Evidence. In Decision 243, the Chamber set a deadline of the 22nd day of July 2022 for the filing of any motions requiring resolution prior to the commencement of trial. The Chamber notes Rule 134, Sub-Rule 2 of the Rules. The Chamber will now ask the parties whether, save any pending request with the Chamber, they have any remaining objections or observations concerning the conduct of the proceedings which have arisen since the 22nd day of July 2022, which was the deadline set by the Chamber. Be mindful that in accordance with Rule 134 Sub 2, no such objection or observation may be raised during the trial proceedings without the leave of the court. Mr. Prosecutor.
Thank you, Madam President. No objections as far as the prosecution is concerned.
Thank you very much. Ms. Nauri, I note your email of, you may want to stand up, please. I note your email of Thursday, the 22nd of September, that you do not intend to raise any objections or observations. Could you kindly confirm that for the record?
Merci, Madame le Président.
Ms. Nauri, thank you, Your Honor. Indeed, as the defense has taken good note of the earlier decision by email on the 21st of September, namely that we could make observations only about things that happened after the 22nd of July. In that situation, the defense has no observations because it would be difficult for us to make this artificial distinction about events occurring before the date in question and those events occurring after.
Thank you very much, Ms. Naui. So in accordance with Article 64(8)(a) of the Rome Statute, the charges will now be read to the accused, following which Mr. Said will be afforded an opportunity to make an admission of guilt or to plead not guilty. As agreed by the parties and the chamber, the court officer will now read the charges, omitting those portions containing confidential information that cannot be read in public session. Madam Court Officer, can you kindly read the confirmed charges to Mr. Said? Thank you.
Thank you, Madam President. The charges against Mr. Said, as confirmed by Pretrial Chamber 2, read as follows. Regarding the contextual elements of war crimes, Pretrial Chamber 2 confirmed that at all times material to the charges, including from at least March 2013 until at least January 2014, there was an armed conflict not of an international character on the territory of CAR. The parties to this non-international armed conflict were distinguished from one another by factors including their affiliation or opposition to François Bozizé, Mr. Bozizé, president of CAR from 2003 until 24 March 2013, even though their outward appearance, military organization, and tactics significantly adapted as time passed and according to the vicissitudes of war. Thus, forces loyal to Mr. Bozizé initially included the CAR Armed Forces, the Forces Armées Centrafricaines, or FACA, and later the coalition known as the Anti-Balaka, and forces opposed to Mr. Bozizé formed a coalition known as the Seleka, led by Michel Djotodia, Mr. Djotodia. Later, after the Seleka temporarily assumed control over the CAR, pro-Bozizé forces, including FACA members and former presidential guards under Mr. Bozizé, regrouped, rearmed, and reorganized themselves as a broader insurgency that became known as the Anti-Balaka. While the intensity of hostilities between the pro-Bozizé forces and the Seleka varied, at no point in this period was the conflict resolved by a peaceful settlement, such as the complete obliteration of one of the parties or a lasting absence of armed confrontation between them. The conduct that forms the basis of the charges in counts 3 to 4 and 6 took place in the context of and was associated with this armed conflict. At all material times, the perpetrators of the charged acts, including Mr. Said, were aware of the factual circumstances establishing the existence of the armed conflicts. 1. The intensity of the armed conflict. The armed hostilities in the CAR between the pro-Bozizé forces and the Seleka were protracted, exceeding the level of internal disturbances and tensions, such as riots, isolated and sporadic events of violence, or other acts of a similar nature, and sufficient to establish a non-international armed conflict. Specifically, in late 2012, the Seleka launched a military offensive in northern CAR, occupying major towns and advancing southward towards Bangui, the capital of CAR. The FACA and other forces loyal to Mr. Bozizé were unsuccessful in resisting their advance. By 24 March 2013, the Seleka were in a position to assault Bangui and drove Mr. Bozizé into exile. Mr. Djotodia proclaimed himself the new president of the CAR. From 24 March 2013, Mr. Bozizé and his allies rapidly regrouped, rearmed, and reorganized to strike back against the Seleka. This led to the formation of the Anti-Balaka coalition, which combined elements of the FACA and the Presidential Guard with pre-existing and new self-defense groups in the CAR. By September 2013, within 6 months, these forces resumed significant combat operations against the Seleka. By 5 December 2013, they were in a position to launch a large-scale attack on Bangui in a coordinated attempt to oust the Seleka. While this was unsuccessful, further intense conflict followed. This led to the resignation of Djotodia on 10 January 2014, the retreat of the Seleka to the north and east of CAR, and the installation, under international pressure, of a non-aligned transitional government led by interim President Catherine Zamba-Panza. 2. The organization of the parties to the armed conflict. At all material times, the parties to the conflict were sufficiently organized so as to establish the existence of a non-international armed conflict. The Seleka were a coalition of several previously uncoordinated political factions and armed groups, including 1. The Union des Forces Démocratiques pour le Rassemblement, the UFDR, 2. The Convention des Patriotes pour la Justice et la Paix Fondamentale, the CPJP-F, and 3. The Convention Patriotique pour le Salut du Codreau, the CPSK. The Seleka exhibited sufficient characteristics to establish that it was an organized armed group, including possessing an ability to carry out military operations and to take and hold territory, and having significant logistical capacity. Likewise, for as long as they constituted the state armed forces, while Mr. Bozizé was president, the FACA comprised a key part of the pro-Bozizé forces and enjoyed a legal presumption of sufficient organization. While Mr. Bozizé's ouster from Bangui was a significant setback, it did not interrupt the effective functioning of his inner circle and persons loyal to him. The pro-Bozizé forces, including elements of the FACA who remained loyal to Mr. Bozizé, were reorganized to pre-existing or new self-defense groups, which came to be known as the Anti-Balaka. To any extent required, and at all times, they were sufficiently organized, as demonstrated by their maintenance of an effective command structure, their ability to carry out complex military operations, and their development of an effective logistical capacity, including to recruit new fighters. Regarding the contextual elements of crimes against humanity, Pretrial Chamber 2 confirmed that from at least April 2013 until at least November 2013, the Seleka committed a widespread and systematic attack against the civilian population in Bangui, perceived to be Bozizé supporters. The Seleka engaged in a course of conduct that involved the multiple commission of Article 7.1 acts, including multiple acts of murder, rape, torture, imprisonment, persecution, and other inhumane acts. This attack was committed pursuant to and in furtherance of a state or organizational policy to commit such an attack against the civilian population in Bangui, perceived to be Bozizé supporters. The Seleka perceived civilians with certain affiliations to be Bozizé supporters, including 1. Christians, 2. People from the ethnic tribes of the Gabaya, Manja, or Banda, 3. People living in certain neighborhoods of Bangui, 4. People who had certain professions perceived to be supportive of Bozizé, such as members of the FACA, former presidential guards who had served under Mr. Bozizé, and people close to them, and 5. People who had been employed by the Bozizé government. The attack included the multiple acts which took place at the detention facility in Bangui, referred to as the Office Central de Répression du Banditisme, Central Office for the Repression of Banditry, the OCRB. The attack further involved non-charged Article 7.1 acts that took place during other incidents in Bangui, such as an assault on 13 April 2013 on the 7th arrondissement of Bangui, a 14 to 16 April 2013 operation in the Boyrab neighborhood of Bangui, an operation in Boyrab starting on 20 August 2013, and an attack on at least 6 passengers taken from a minibus at the PK9 checkpoint in Bangui on or around 13 July 2013. The attack was systematic. The crimes comprising the attack were not committed at random. The crimes at the OCRB were 1. Planned, coordinated, and overseen by Seleka commanders, 2. Committed by the Seleka on a regular basis over a substantial period of time, and 3. Executed by the Seleka according to a consistent pattern. The attack was widespread. The attack was directed against a civilian population living in densely populated neighborhoods in Bangui, the country's largest city. The attack resulted in a large number of victims. The Article 7 acts in counts 1 to 2, 5, 7 of these charges were committed as part of this widespread and systematic attack. As a senior leader of the Seleka, and an individual who was often present at the location of the charged crimes, Mr. Said knew and intended for his conduct to be part of the widespread and systematic attack against the civilian population in Bangui, perceived to be Bozizé supporters, pursuant to and in furtherance of the state of organizational policy. Regarding the common elements of modes of individual criminal responsibility, Pretrial Chamber 2 confirms that at all material times relevant to the crimes charged in counts 1 through 7, committed between 12 April and 30 August 2013, Mr. Said was a senior Seleka colonel operating in Bangui. After the Seleka's military advance and takeover of Bangui, Mr. Said was a direct subordinate of Noureddin Adam, Mr. Adam, who was the Minister of Public Security until 22 August 2013. Mr. Adam appointed Mr. Said as the de facto head of the OCRB, effectively putting him in charge of this police unit, including all Seleka who were stationed there. In this position, Mr. Said had full authority over the Seleka elements, OCRB Seleka, stationed there. In this role, Mr. Said oversaw the functioning and conditions of the OCRB detention center. Mr. Said exercised control over the OCRB Seleka stationed at the OCRB who complied with his instructions. Mr. Said provided them with supplies and ordered the arrest, detention, and mistreatment of persons targeted on political, ethnic, religious, and/or gender grounds by the OCRB Seleka. He personally participated in arrests and interrogations. Mr. Said is individually criminally responsible for the crimes charged in counts 1 through 7, committed at the OCRB between 12 April 2013 and 30 August 2013 for committing those crimes jointly with others, Article 25(3)(a), and ordering or inducing those crimes, Article 25(3)(b). Concerning the charged crimes, Pretrial Chamber 2 confirmed that between 12 April 2013 and 30 August 2013, Mr. Said, together with the OCRB Seleka, targeted perceived Bozizé supporters by arresting, detaining, and mistreating them at the OCRB. The targeted victims were 1. Predominantly Christians, 2. Predominantly belonged to the Gabaya, Manja, or Banda ethnicity, 3. Predominantly males, and 4. Predominantly from certain neighborhoods in Bangui, like Boyrab, perceived as supportive of Bozizé. These victims were targeted for arrest on political, ethnic, religious, and/or gender grounds. Mr. Said and the OCRB Seleka severely deprived, contrary to international law, these persons of fundamental rights, including the rights to life, bodily integrity, private property, freedom of movement, and freedom from torture or cruel, inhumane, or degrading treatment. The OCRB Seleka violently arrested these victims, often at night, and beat and hooded them. At the OCRB, which was an enclosed compound not publicly accessible, surrounded by high walls and guarded by armed OCRB Seleka, the perceived Bozizé supporters who were arrested were detained in small cells. Overall, the detention conditions were dire, as the detainees were held in dark, hot, cramped cells and not provided with adequate food, water, or regular independent medical attention. During the charged period, the OCRB Seleka arbitrarily detained persons who were predominantly male at the OCRB. They deprived them of fundamental rights contrary to international humanitarian and human rights law, including having access to prompt independent review of the basis of their detention and humane treatment. While some detainees learned during their interrogations that they may have been suspected of being a fighter or a spy for Mr. Bozizé, others were merely accused of protesting the Seleka regime, supporting Mr. Bozizé politically, or being from the Gabaya, Manja, or Banda ethnic groups. During the relevant time frame, individuals were detained in a small and overcrowded underground cell by Mr. Said's office. The OCRB Seleka, under Mr. Said's control and with his support, mistreated detainees on an almost daily basis. Mr. Said oversaw the detention of men who were beaten with rifle butts or slapped violently and threatened with death. Others were whipped with horsehide whips or sticks with metal wires, beaten with truncheons on their feet while kneeling or with rifle butts, burnt or had their ears pulled with pliers and partially ripped off. Some men were inflicted with severe physical and psychological pain and suffering by having their hands, elbows, and feet tied together tightly behind their backs in a method called arbatachar. In line with the Chamber's instruction, I omit paragraph 29 of the confirmed charges as it contains confidential information. I will now proceed with reading the remainder of the charges. The facts referred to in paragraph 29, constituting the factual basis for counts 1 to 6, also form the underlying conduct of the crime of persecution, count 7. This conduct was committed in connection with these crimes. At the material times, Mr. Said and the other perpetrators targeted the victims who were perceived as Bozizé supporters as described above, on political, ethnic, religious, and/or gender grounds. Mr. Said was aware of the factual circumstances that established the gravity of the conduct, such that it violated fundamental rules of international law, as charged in count 1. Mr. Said knew that detainees were arrested on an arbitrary basis, deprived of their right to prompt independent review of the basis of their detention, held in dire conditions, and subjected to severe physical and/or mental treatment. Mr. Said knew that the perpetrators inflicted the pain or suffering on detainees at the OCRB for such purposes as obtaining information or a confession, punishment, intimidation, or coercion, or for any reason based on discrimination of any kind, count 3. Mr. Said was also aware that the persons detained at the OCRB were civilians or persons hors de combat, counts 4 and 6. Mr. Said was further aware of the factual circumstances that established the character of the acts as charged in count 5, as acts similar to other acts referred to in Article 7.1 of the statute. Regarding Mr. Said's individual criminal responsibility, Pretrial Chamber 2 confirmed the following forms of criminal responsibility. 1. Under Article 25.3a of the statute for directly co-perpetrating crimes at the OCRB. Mr. Said and Mr. Adam, Tahir Babikir, Hisene Dambucha, Yaya Sumayele, Muhammad Salet Adum Kete, Adum Rakis, Fadul al-Bachar, and other members of the OCRB Seleka shared a common plan or agreement to target perceived Bozizé supporters in Bangui by committing the crimes charged in counts 1 through 7 at the OCRB Common Plan. The crimes charged in counts 1 through 7 were committed by the co-perpetrators, including Mr. Said, and occurred within the framework, and resulted from the implementation of the OCRB Common Plan. The OCRB Common Plan came into existence as soon as 12 April 2013. Mr. Said made an essential contribution to the Common Plan until 30 August 2013 by arresting and detaining perceived Bozizé supporters at the OCRB, including the detention of victims in an underground cell situated by his office in the OCRB. Instructing OCRB Silica to mistreat detainees who allegedly supported Mr. Bozizé, including by tying them up using the painful abattoir method. Supplying the OCRB Silica with weapons, food, uniforms, and ID cards. Interrogating detainees violently and supporting such interrogation methods by OCRB Silica, and overseeing the overall functioning of the OCRB Detention Center, including the detention conditions, by giving instructions and orders to the OCRB Silica, deciding who could get access to the judiciary, and by reporting to Mr. Adam. Mr. Said meant to engage in the conduct described above and intended to bring about the objective elements of crimes charged in counts 1 through 7. He was also aware that the implementation of the OCRB Common Plan would, in the ordinary course of events, result in the commission of the type of crimes charged in counts 1 through 7. Mr. Said was aware that the OCRB Common Plan involved an element of criminality. He was also aware of his essential role in the OCRB Common Plan, the central nature of his contributions, as set out above, and of his ability, jointly with other co-perpetrators, to control the commission of the crimes. Two, under Article 25(3)(b) for ordering crimes at the OCRB. Mr. Said ordered members of the OCRB Silica, over whom he had a position of authority, to commit the crimes charged in counts 1 through 7. Mr. Said gave instructions to his subordinates to use the abattoir method, praising this method as the best way to extract confessions. He supported other forms of severe mistreatment. Mr. Said gave instructions to his subordinates to detain men in the small, dark, and overcrowded underground cell by his office, where they were provided little food and water and no access to independent review of their detention. Mr. Said meant to engage in this conduct and was aware of his position of authority over the physical perpetrators of the crimes. Mr. Said meant for the OCRB Silica to commit these crimes and or was aware that in the ordinary course of events they would commit the crimes and was aware that this conduct would contribute to their commission. 3. Under Article 25(3)(b) for inducing crimes at the OCRB. Through the conduct prescribed above at paragraph 34, Mr. Said induced the OCRB Silica to commit the charged crimes. Mr. Said exerted influence over the OCRB Silica, prompting them to commit the charged crimes. Mr. Said meant to engage in the conduct described above. Mr. Said meant for the OCRB Silica to commit these crimes and or was aware that in the ordinary course of events they would commit the crimes and was aware that this conduct would contribute to their commission. The pretrial chamber gave the following legal characterization of the above facts and held Mr. Said criminally responsible for. Count 1. Imprisonment or other severe deprivation of physical liberty as a crime against humanity at the OCRB of persons perceived to be Bozizé supporters between 12 April 2013 and 30 August 2013, including, as summarized in paragraphs 29A to R, punishable under Article 7(1)(e) and pursuant to Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 2. Torture as a crime against humanity of people perceived to be Bozizé supporters who were tied using the abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, punishable under Article 7(1)(f and Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 3. Torture as a war crime of people perceived to be Bozizé supporters who were tied using the abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, punishable under Article 8(2)(c), subparagraph I and 4, and pursuant to Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 4. Cruel treatment as a war crime of people perceived to be Bozizé supporters who were tied using the abattoir method between 12 April 2013 and 30 August 2013, as well as other detainees who were severely mistreated, including as summarized in paragraphs 29B, 29E, 29H, 29M, and 29Q, as detained under dire conditions at the OCRB, punishable pursuant to Article 8(2)(c), subparagraph I and 3, and Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 5. Other inhumane acts as a crime against humanity of people perceived to be Bozizé supporters who were detained in deplorable conditions at the OCRB, who were verbally and physically abused, including during interrogations between 12 April 2013 and 30 August 2013, including as summarized in paragraphs 29A to R, punishable under Article 7(1)(k) and Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 6. Outrages upon personal dignity as a war crime of people perceived to be Bozizé supporters who were detained in deplorable conditions at the OCRB and/or were tied using the abattoir method and/or were verbally and physically abused, including as summarized in paragraphs 29A to R, between 12 April 2013 and 30 August 2013, punishable under Article 8(2)(c), subparagraph 2, and Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute. Count 7. Persecution as a crime against humanity on political, ethnic, religious, and/or gender grounds concerning the people detained at the OCRB based on the facts underlying counts 1 through 6, including as summarized in paragraphs 29A to R, and punishable under Article 7(1)(h) and Articles 25(3)(a), direct co-perpetration, and 25(3)(b), ordering or inducing of the Rome Statute.
Now, thank you very much, Madam Court Officer. Now, Ms. Nori, Defense Counsel, can you please confirm that you have explained the nature of the charges Ms. Naui, can you stand up, please? Can you please confirm that you have explained the nature of the charges to Mr. Said and his right to make an admission of guilt or to plead not guilty to the charges? Can you confirm that, please?
Merci, Madame le Président.
Thank you, Rona. I was just waiting for the translation to end. I confirm that we have discussed in detail the charges, and Mr. Said is aware, and he's also aware of his rights to either plead guilty or not. And I can inform you that we are here because he has decided to plead not guilty. Thank you so much, Your Honor.
Thank you very much. If we can hear that from Mr. Said. Mr. Said, can you rise, please? Good morning again.
Oui, bonjour, Madame la Présidente.
Good morning, Your Honor.
Now, do you understand the nature of the charges read out to you today?
I've listened to everything and I'm pleading not guilty.
You pleading not guilty to all the charges or to some of the charges or to any of the charges?
Je plaide non coupable sur toutes les situations.
I'm pleading non guilty to all charges and all situations.
Thank you very much, Mr. Said. You may be seated. Can you turn your microphone off, please? Thank you. So we'll now turn to the opening statements. The prosecution will commence its opening statement today and have been allotted 4.5 hours. I know you said you'd use less time. I note for the record, in line with the directions given to the parties on Thursday, that speakers must speak slowly and observe the 5 seconds rule for the interpreters and court reporters. Furthermore, please indicate if you are shifting from one language to another. Ms. Naui? Ms. Naui, please. Defense Counsel. Ms. Naui?
Merci. Pardon.
Sorry, I was just reading the transcript. Thank you. We're going to plead in French because that's the working language of the defense team.
I just wanted to catch your attention to what I'm saying to the court, please, to both counsel. So, furthermore, please indicate if you are shifting from one language to another to assist the interpreters and for the accuracy of the record. Mr. Prosecutor, you may now make your opening statement. Thank you.
Madam President, Your Honours, I am acutely aware that as we speak, outside of this courtroom, in the Central African Republic, and particularly in Bangui, people are riveted to their screens. I applaud the registrar of this court, Mr. Peter Lewis, and the colleagues at the registry for ensuring that there was sufficient attention given to try to help the people of the Central African Republic follow these proceedings. They have been patient, and they have shown a great deal of stamina, waiting 9 years to be able to have this trial start. I'm grateful, Madam President, to the court officer for detailing the charges and the parts of the confirmation decision, and for the diligent, painstaking work of the pre-trial chamber. But the matter now is in your hands, and we're blessed to have 3 independent and impartial judges that will assess the merits of the prosecution's case, subject it to scrutiny, and decide whether or not we have proved that case beyond reasonable doubt. We say we have, and by the end of this trial, you will be convinced that in relation to all 7 counts, Mr. Said will be found guilty. Madam President, Mr. Said has entered not guilty pleas, and that is his right, and there is a presumption of innocence. But the beauty of the law is that there is no place to hide. And in the course of this trial, Mr. Said will be confronted with evidence, with witnesses that knew him, that fell into his hands or were apprehended by him, and they will speak in relation to the charges that were confirmed. As I mentioned, this has been a day long in coming. This is the first time a senior member of the Seleka has appeared before this court for trial. And the charges that are faced are really quite awful. And they are reflected to some extent in the confirmation decision. Charge of imprisonment, of persecution, torture. And these were not isolated incidents. They were, for the reasons you will hear, part of a widespread or systematic attack directed against the civilian population. And part of this attritional violence between the Anti-Balaka and the Seleka. This is the tragedy of so many countries, and it is certainly the tragedy of the Central African Republic, that these groups focused and vied for power, for hegemony, and not for the interests of the people who far too often were caught up or targeted and suffered as pawns in a greater game. The discrimination underlying the grounds of persecution will also be a feature of this case and will be elaborated upon in due course. My portion of the opening is really going to be focused on an orientation. What is the OCRB and where was it? Deputy Prosecutor Niang will then speak in French, and he will go into much more detail, followed by the senior lawyer in the case that sits behind me, Aholo McQuay. Between the 24th of March 2013 until the 10th of January 2014, for 10 horrendous months, the Seleka ruled Bangui. To say they governed would be an abuse of the English language. They ruled by diktat, by fear, by terror. And they targeted individuals that they perceived as being on the other side, not because they were combatants, but simply because they believed they were on the side of former President Bouzizi. And Mr. Said was in charge of the location that we will zoom in and focus on in the course of this trial, the OCRB, at least between mid-April 2013 and August of that year. And he was in charge of about 35 to 60 Seleka members. And along with Mr. Yahya Somaili and Mahmoud Tahir, his voice determined the fates of so many individuals. He brought people to the OCRB. He did not protect them. but rather he actively participated in their capture, hunting them down, and subjecting them to the most dire conditions that he could conjure up. Although a de facto leader, Mr. Said wielded immense power. And in fact, in that area, and definitely in the OCRB, he was only ahead of him was Mr. Nuruddin Adam. Madam President, perhaps if we can go to evidence 2 on your monitors, we will show a map of Bangui, and you will see there in red the OCRB is marked, and along with that are the locations of other incidents that you and the members of the public will hear in the course of this trial. To the north we have the 7th arrondissement, to the northeast. Above that we have Boy Rabe, which has 2 incidents detailed in April 2013 and August 2013. To the west, we have an awful incident, executions at the PK9 minibus incident, and they were then taken to the river and thrown dead, and their bodies, some of them were recovered, but they were certainly photographed. And then we have Sedad, not too far from the OCRB. But if we move to the next photograph, Madam President, you will see an aerial shot of OCRB. You will be able to make out perhaps a larger building towards the north of the picture and outhouses. And if we move down from the air, we will then see the gate of OCRB. This was the outside world's view, people that were passing. This is what they saw. A pre-existing base used by the Seleka for criminal purposes in the prosecution's respectful submission. And Madam President, if we look at the video in front of you in a few moments, you'll see a compilation that's been put together by the Office of the Prosecutor's Forensic Section from missions in 2016. This shows the inside of the compound, and first of all, you will see the main office building to your left. To the right, you will see some other cell buildings, including towards the southeast, which are marked on the video G5 to G7. These are cells in which men were detained and subjected to what the prosecution says was grotesque abuse. And right across from the OCRB building, there's another cell block, which includes 4 more cells, which you can see labeled G1 to G4. Around the whole perimeter is a high wall, and if we keep moving, Madam President, we'll come to the gate that you see now on the right-hand side of the picture, and we started with a picture from the other side, from the road, in which OCRB was emblazoned upon it. If we go, with the help of Ms. von Braun, to the main building, we can go inside. And inside this main building, Mr. Said had an office. And perhaps we can go into that office. Because in that office, he controlled the whole of the facility. And what is more, literally under his feet, he put civilians in a space called the hole. In that hole, civilians were kept in really putrid conditions, filth around them, their own feces, stale air, lack of ventilation, treated not as humans, not even as animals, a class below. Their humanity apparently eviscerated by the policies and action of the accused that faces trial in these present proceedings. There they were not given water. There was no due process. They were cut off in every sense from the protection of the law. And those victims come to this court and will come before your honours to have their rights vindicated, to have a determination underlined that what took place was wrong, it was illegal, and it was against the provisions and the protection of the Rome Statute. I would ask that we can play the video. And this is taking your honours into the hole. 9 witnesses will give evidence in the course of these proceedings about what it was like to be down in that space where the air was rank, stale and stinking, with a lack of ventilation, given the number of people that were crowded together. You will hear them speak about having to sit in feces, the bucket they were given overflowing, rats running around. And this dump, this hole away from the light of legality, is not the only place where these poor souls were kept. 6 other cells were above ground. We've shown those from outside. But the conditions were similarly dire, so bad in the heat, emaciated and thirsty, compelled to drink their own urine to quench the thirst in such a deprived and unnecessary manner. And I'd ask that we could also play the video of one of those rooms. This is room cell G3. When the door is closed, it is dark inside. And you'll hear witnesses saying that it was so crowded, they couldn't even lie down. Madam President, the courtyard that you're looking at was not a safe haven. Witness after witness will testify that they came out from those cells, not for fresh air, but for beatings. Beatings with all kinds of instruments, gun butts, whips, to make that not inconsiderable pain cut even deeper. Witnesses will describe having their backs covered in mud or soil or gravel, so that the lacerations would go deeper and the whips would cut more effectively. Madam President, you will hear, and Your Honours, what the court officer mentioned regarding the abachacha method, a singular design of tying a person's hands and elbows and feet together behind their back in a way that strains every ligament, causes agony, not just discomfort, and left so many with partial paralysis, temporary paralysis, and numbness. And these wounds cut deep, indeed. You will see some photographs in a moment. But what the photographs do not tell is what perhaps Your Honours will hear in the course of this trial. The psychological effects of that treatment, which can be just as profound as the physical cruelty and torture the prosecution allege Mr. Said committed against these individuals. Many, many remain traumatized today. Many can't move in the manner they could before they fell into the hands of Mr. Said, the Salaka, and his henchmen that were in charge of OCRB. At least 16 people were tied in the Arabacha method. One example is P547, and God willing, Your Honours will hear his testimony soon. You can see with the naked eye the deep lacerations into his arms. The Arabacha seared his flesh, and years later, it is all too apparent. Marked for life, because the prosecution allege Mr. Said did not intervene, did not protect, did not lift a little finger to use any iota of his authority to alleviate their suffering. Rather, he deliberately exacerbated it in many ways that he could. P547 lived to tell the tale, and his voice, Madam President, represents other victims who were beaten and tortured at the OCRB and not photographed. They will tell you about the mental anguish and the pain and the distress that they feel today. Now, the prosecution alleged that Mr. Said was not a passive spectator, not simply somebody who failed to prevent and repress and punish, but he actively hunted down civilians himself and brought them to the OCRB, knowing exactly what he had planned for them, what nightmare awaited them under his control and custody. For example, P3053, P3056, P3064 will all testify about being apprehended not by unknown individuals, but by the person who is in the dock, brought by himself. And also, you will hear evidence from the prosecution that Mr. Said also ordered the arrest and detention of Mr. Oswald Sons and 2 other men who were detained in the OCRB. And you'll have evidence also that the OCRB, with that high wall and perimeter and the forbidding gate, was guarded by Salaka members with heavy weapons. People couldn't escape, even if they were not hamstrung with the Arabacha method. This was no office to repress banditry. This was no location to assess any criminal conduct. This was a torture center, designed as such to spread terror, hardship, and pain. The evidence comes from many sources. And Madam President, Your Honours will hear not just from victims and survivors, but from insiders, people that worked with Mr. Said, that saw his actions, that can testify to his presence at the OCRB, such as P2105, P2161, P2563. You'll hear evidence of relatives. Imagine that. awful to be tortured without protection of the law. And when some have managed to find out, sniff out, where their loved ones have been taken, imagine the desperation because of the state of the unknown and knowing what was happening in that period. And you'll hear evidence from P2241, P2692, P3053, P3064, P3056, that they were forced to pay what was for them enormous sums of money to the accused and the co-perpetrators mentioned in this case to obtain the release of their loved ones. A bit of profit, perhaps, on the side of the cruelty that was being committed. And the evidence will show powerfully that the accused at no time disciplined any of his subordinates with respect to what he saw, the degrading treatment, the ill treatment of the people that were there in the OCRB. As I mentioned earlier, Madam President, figuratively and literally, below the room in that hole, Mr. Said had his feet on the heads of his fellow brothers in Bangui. But little surprise, perhaps, the prosecution allege that he didn't prevent or punish, because P338 will testify that Mr. Said told him himself the Batacha method was the best way to secure confessions. Mr. Said's crimes, alleged by the prosecution and confirmed by the pretrial chamber, were not isolated or spontaneous acts, but were committed as part of a widespread or systematic attack and constitute crimes against humanity. He knew, Mr. Said clearly knew, and had knowledge that his own conduct formed part of that wider attack, because he also took part in those wider attacks. Madam President, one of the features of this case is the discriminatory nature of what took place. When the Seleka took power on the 24th of March 2013, ousting President Francois Bozize, the evidence will show that with no finesse, with no attempt at discernment or distinction, individuals with certain attributes were targeted because they were deemed a threat to the Seleka. They were targeted on political, ethnic, religious, or gender grounds, sometimes these intersecting grounds as well. Christians, Faka, presidential guards, ethnic groups such as the Baya, the Manja, and the Banda. Sometimes it's enough just to live in a certain locality, like Boirabe. You were perceived, those unfortunate souls were perceived by dint of their residence, where they had managed to find a home, to be supporters of the previous regime. And Madam President, you will hear evidence of the attacks on the neighborhoods of Boirabe, where men, women, and children were killed. Women and girls were raped. Men and boys arbitrarily arrested, and houses systematically looted. After these attacks, the hospitals of Bangui were full of the injured. And on the picture before you, Madam President, you'll see a photograph taken by a journalist, witness P342. An individual being brought to the hospital. Some of the fruits of the Seleka efforts. Weird fruit, as the song goes. Strange fruit, as the song goes. Mr. Said knew about these attacks and the policy as he was a senior member of the Seleka and was in a position of authority directly subordinate to the Minister of Public Security, Mr. Nuruddin Adam. And witnesses will testify that he took part. Mr. Said himself took part in some of these attacks. He looted goods himself and brought them from Boy Rabe back to OCRB himself. Looting to go with the cash for hostages, cash for prisoners, release that we have already spoken to. In April 2013, the Seleka attacked the 7th arrondissement, looting and killing, and you'll see another photograph, P312, who will testify in these proceedings, God willing, a civilian, escaped with his life by the narrowest of margins. The wound itself shows how fortunate he is to be alive. And in July 2013, 6 to 8 men were taken from a bus at PK9, if you remember the first map, towards the west of Bangui, and brought to Camp Daru, executed in fact, and thrown in the water. We can see those individuals floating, not just corpses, but beloved sons or children to those whose families they belong to. This is not easy for the people in Bangui to watch. It's not easy for them to hear. But the reason we have trials and we have due process is to separate specious from the truth. And it's our belief that in the course of this trial, the truth will out. And those that are responsible for this, and Mr. Said himself, will have a chance to answer as to why he says he's not guilty. But we assert in any event that the evidence will show that all 7 counts are proved beyond reasonable doubt. The Seleka didn't bring peace. They brought misery. And in the course of this opening, in fact, it will be the part led by senior trial lawyer Hola McQuay, you'll also see a variety of the evidence that the prosecution has in terms of testimonial and documentary evidence, including military reports and email communications, that will demonstrate beyond reasonable doubt the responsibility of Mr. Said. You will see identification cards that Mr. Said issued, bearing his own initials. He was a man of great power. How unfortunate it is for the people of the Central African Republic. How unfortunate it is for Mr. Said that he didn't use that authority, that power, properly and humanely, but instead abused his own people. Madam President, on the 28th of July 2022, the arrest warrant for Mr. Nuruddin Adam, the former Minister of Public Security and second in command of the Seleka, was unsealed. Mr. Adam, of course, was the immediate superior of Mr. Said. It's only right to use this opportunity, with your leave, to reiterate the importance for justice that the warrants issued by this court and by judges of this court are executed in a timely manner, because victims have a right to the truth. At the same time, this office that I have the honor to lead has been trying to work more closely with the special court in Bangui, to give further dynamism to the spirit of complementarity. We will endeavor to deepen that so that there is more justice, and the evidence that my office has collected can find a home in independent courts wherever that is possible. But for today, and at this moment, the eyes and the focus is on Mr. Said and what he did and what he chose not to do. With your leave, at the end of this opening speech, and certainly by the end of this trial, I am convinced when you've heard from the opening of Deputy Prosecutor Niang and the senior lawyer in the case Holla McQuay, you will have a much better picture of the strength of the prosecution evidence and why we say with confidence that this is a case that you will be able to be convinced about beyond reasonable doubt, that Mr. Said is responsible and did commit all 7 counts that were confirmed in these proceedings. Thank you so much. And with your leave, Madam President, perhaps I can pass the floor to Deputy Prosecutor Niang.
Thank you very much, Mr. Khan. Mr. Niang, I note you have like 12 or 13 minutes more. Would you want to start your own part of the opening speech?
Mr. Nyang, if you don't mind, it's up to you. If you think it would be better to start after the break, that would be fine. Of course, it's really your call, Madam President.
Thank you very much. I'm just looking at the time. Okay, you may start now. If it's 11 o'clock and we're not done, when we come back after the break, you could continue. Thank you. Carry on, please.
Merci.
Mr. Niang, thank you, Your Honor. Madam President, Your Honors, it is with humility and a deep sense of duty that I appear before you today for the first time. And also it is with the same humility that I'm honored to speak after the prosecutor, Mr. Karim Khan, KC, who has already provided a backdrop for this case. I will now provide a description of the prosecution's case against Mr. Said. And I think I will need 40 to 50 minutes. I certainly will not go beyond the time allocated to me because the Chamber has already received a detailed overview of the case in the pretrial brief provided to you. Today, I will speak to the high points, the main evidence that the prosecution will be adducing, which constitute the main events that occurred and the main elements that allow us to create the charges and determine the mode of liability. The Chamber will be convinced beyond all reasonable doubt that Mr. Said is guilty of the crimes that he has been charged with. And this criminal liability is personal in nature for war crimes, crimes against humanity committed at the Central Office for the Repression of Banditry. You all saw the videos and the photographs. This place was known as the OCRB between the 12th of April and the 31st of August of the same year, 2013. The prosecution will be basing itself on its evidence to prove the worthiness of its cause. As Prosecutor Khan has already mentioned, we will rely not only on testimony, we will also rely on video footage and written evidence and digital forms evidence that will show the accused person's guilt beyond any shadow of a doubt. We will also be adducing evidence from insiders, people who have experienced what happened with the accused person, the people who are actually present during the period of time covered by the charges and who are familiar with the accused person's behavior and attitudes. Your Honors, during this trial, you will hear poignant testimony from victims who suffered at Mr. Said's hands and at the hands of his co-prosecutors, some of whom were already mentioned by Mr. Khan. Madam President, Your Honors, first of all, I will set out the events that show the responsibility of Mr. Said's responsibility for what happened at the OCRB before I move on to the evidence that set out the constitutive elements of war crimes and crimes against humanity. First of all, we will begin with Mr. Said's role at the OCRB. Mr. Said has been accused, and the 7 counts are now shown on the screen. First of all, imprisonment or another form of severe deprivation of physical freedom constituting a crime against humanity, count 2. Torture constituting a crime against humanity, count 3. Torture constituting a war crime, count 4. Cruel treatment constituting a war crime, count 5. Other inhumane acts constituting a crime against humanity, count 6. Indignities upon a person constituting a war crime, and finally, count 7, persecution constituting a crime against humanity. Madam President, Your Honors, the prosecution argues that Mr. Said perpetrated these crimes jointly with other people, and this is in the meaning of Article 25(3)(a), and he ordered or encouraged the commission of these crimes in the meaning of 25(b) of the statute. The evidence that will be brought before this court will show that Mr. Said, a high-ranking member of the Seleka coalition, led these elements of the Seleka at the OCRB at the time of the crimes covered by the crimes between April and August of 2013. On the 12th of April 2013, or around that particular date, Nuruddin Adam, who a leading member of the Seleka and Minister of Public Security, appointed the accused person as the head of the OCRB. This appointment occurred shortly after the time when the coalition took control of Bangui, and President Bozizé was ousted, and then he fled the country. Within this position, Mr. Said had full authority over Seleka elements who followed his orders, as the prosecutor mentioned a few moments ago, and as the evidence shall demonstrate in the course of this trial. He supervised the day-to-day operations of the OCRB, as well as being responsible for the conditions of detention. He also managed the imprisonment of those being held. Not only did he lead the Seleka at the Seleka and supervised them. He also provided them with the resources they needed, the money. He provided food, uniforms, and even weapons. He also ordered them to arrest people, to put them in detention, and to mistreat them. Seleka elements and police officers assigned to the OCRB during the time covered by the charges will appear before the court to testify. In April 2013, when the Seleka took control of this office, the Central Office for the Repression of Banditry, this place had already been used as a holding center for detainees in Bangui. You will hear from witnesses that for more than 4 months, the accused person filled these cells with people who had been detained and held in an arbitrary fashion. You will see a number of photographs which will be quite striking. The complex was surrounded by a high perimeter fence, and it was almost impossible to escape. The only way to escape was to take tremendous risks, even the risk of losing one's life. Your Honors, the people who survived the crimes charged will give testimony. They will tell you that there were 6 cells at ground level. You have already seen these cells in the photographs shown earlier. These people were held for long periods of time, and as you can see on the next slide, these cells were cramped and had no windows. In addition to the holding cells at ground level, there was an underground cell called the hole. You saw an image of the hole earlier today, and that hole was used to hold other prisoners. They too were there, literally under the office of the accused person. Mr. Khan mentioned a very striking fact, namely that these people were literally under the feet of Mr. Said. Many people were held by the Seleka at the OCRB in the most horrific and inhumane conditions that one can imagine, deprived of their most basic rights and of any guarantee of normal proceedings. It was not easy for Witness 2400 will testify that he had to jump into the underground cell. There was no ladder leading down. There were no steps. One literally had to jump into the cell. He will tell the court that the cell reeked of urine and feces, and that it was dark and cold in the cell, and the floor of this underground cell was covered in garbage and dirt. In the OCRB cells, people who were considered to be supporters of Bozizé were held. Christians, members of certain ethnic groups who were targeted, the Gabaya people.
It's a good time to stop, and so that we can adjourn and come back at 11:30 for a short break. Okay?
D'accord, Madame la Présidente.
Very well, Your Honor.
Thank you. Madam Court Officer, can we adjourn till 11:30, please?
All rise. We will